Chapter 5 Business Organizations. So, you want to start a business. There are several different ways businesses organize themselves to protect the business owners and the business assets. Each business entity has certain drawbacks and certain benefits. We are going to discuss each of these entities at length. Some entities, such as sole proprietorships, are simple, whereas others, such as corporations, can be quite complex. Be aware that these entities can sometimes commingle. You may have an LLC owned by a corporation or as a member of a partnership. Which business entity is right for me? There are several factors a business owner must consider when deciding which type of business entity to organize into. This could include tax issues, the number of people that own the business, and how it's managed, among other factors. The following are some things to consider. Limited liability. Many businesses offer limited liability to the owners. Limited liability means that the owners have their personal assets protected from the liability that comes from bankruptcy, lawsuits, and other bad things that may happen to the business. If a business fails or lacks the assets to cover a lawsuit, the owner does not want to lose their house, their car, or their dog. Corporations, limited partnerships, and limited liability companies are best known for providing limited liability to their owners. Taxation. The way a business is organized can impact the tax on it. Many entities report their taxable income only once on the owner's personal tax form. Other entities are taxed twice on the same income and must report as a business. Formalities and management. Each of these business entities have different requirements attached to their management. This can impact the paperwork creating and maintaining the business. This can include meetings by the owners and managers. Some entities require very little maintenance and management. Others require control by many different parties, each with unique duties. Financing and liquidity. The organization of the business may impact ownership of the assets and the ability to achieve financing from the bank. A large corporation is more likely to be accepted for a loan than an individual shareholder/owner of that corporation. However, the limited liability provided by a limited liability company may result in it being more difficult to get financing because the owner's assets are not at stake. Some business owners are happy to keep their personal assets separate from the business assets, keeping their personal equipment and money separate. Others, particularly those starting out a small business, may be unable to do that and need to be able to commingle their personal and business assets. Life of the business. What sort of business entity you choose can impact how long the business survives. Some entities, such as corporations, can last forever. Others, such as partnerships, may be required to end with the leaving of a partner. In some states, their laws may impact how long various business entities can exist. Next, we'll discuss each of these business entities. Sole proprietorships. The simplest business entity we're going to discuss is the sole proprietorship. This is the easiest entity because it's just you. Look at you, starting your own business. I bet mom and dad are proud. Wait, a vape shop? Okay, I take that back. There's literally nothing you need to do to create a sole proprietorship. You simply start a business and you're ready to go. The major advantages of a sole proprietorship are the fact that you don't have to answer to anyone. It's just you. You're your own boss. This is half of why you started your business, isn't it? Keep in mind that while you simply need to start business, this does not necessarily relieve you from other responsibilities for any other business licenses if other factors are triggered. Another major advantage of a sole proprietorship is that your business is not required to file taxes. Your income is reported on your personal return as business income. So you needn't file any paperwork with the state, you don't have to run your brilliant idea by anyone else, and you can just get to work. So where's the downside? You have unlimited liability. This means that your personal assets are not protected if something bad happens. Perhaps your business gets sued for one of the torts we've discussed. Maybe you didn't even do anything wrong, but you happen to sell something and end up involved in a product liability lawsuit. In this case, not only is your business going to suffer, but you'll suffer too. If your bank account can't handle your debts, court judgments, or other liabilities, you might lose your house, your car, or your dog. Bankruptcy might be in your future. General partnerships. General partnerships are also quite easy to create. With a sole proprietorship, you just start getting to work. With a general partnership, you and your buddies just get up and start getting to work. The owners of this entity are called partners. General partnerships are also not required to file taxes for the business. Income flows through the business entity, and like with a sole proprietorship, each partner reports their profits and losses on their personal income taxes on a separate form for business income. When it was just you and a sole proprietorship, you had no one to answer to. There were no disagreements because there was no one to disagree with. Now, with you and your fellow partners, there's all sorts of room for disagreement. To head off these disagreements and to help govern the partnership, each state has incorporated by statute the Revised Uniform Partnership Act, called the RUPA. The RUPA is not law in and of itself. What is law is the version of the RUPA that your state has decided to codify. Most states follow the rules of the RUPA closely, but apply a few modifications, especially as it relates to the withdrawal of members. Your state's RUPA will apply to all partnerships within the state, whether a general partnership, limited partnership, or limited liability partnership. The RUPA rules go into place the minute you create a partnership. How do you create a partnership? A partnership is the association of two or more persons to carry on as co-owners a business for profit, whether or not the persons intend to form a partnership. That's a fancy way of saying that if you start a for-profit business with someone, you're in a partnership. The second portion, whether or not the persons intend to form a partnership, is vitally important because when you become partners, the RUPA applies. You might actually be operating under a different set of rules than you initially expected. People frequently find themselves in a partnership and subject to the RUPA rules against their own interest, as the definition of a partnership can be much looser than what you intended between the individuals involved in the business. Case law is full of situations where the courts must resolve this very issue. The rules of the RUPA exist in the absence of a written partnership agreement. It is possible to modify many of the following rules so long as it is put in writing according to the rules of your state's RUPA. The most common terms behind the RUPA relate to the fact that every partner receives an equal portion of the business's profits, that each partner may be an agent for the partnership, that all partnership agreements must be unanimous, and that each partner has a fiduciary duty to the other partners. There are also complex rules about winding up the partnership and paying out the partners. Each partner is an agent to the partnership. This means that each partner may make legal decisions and speak on legal matters for the partnership. The partnership is a legal entity separate from its members, so a partner is not speaking for herself, but rather for all the partners. This includes if they violate that second term, then all partnership agreements must be unanimous. If a partner binds the partnership to a contract or other legal matter in the absence of a unanimous agreement, that may be bounds for a lawsuit or being kicked out of the partnership. But that may not necessarily relieve the partnership of its obligation to pay. Partners owe each other a fiduciary duty. Fiduciary duties are a special relationship individuals have to work in the best interest of certain other people. Partners must be loyal, honest, and put the partnership first. Imagine that you are a general partner in a delivery business. The business could always use new vehicles, and you see a spectacular deal on a new pickup. But you find you also need a new vehicle, and that pickup looks rather appealing. Because of your fiduciary duty to the partnership, you owe the partnership to notify them of the deal and give them an opportunity to purchase that vehicle before you get the opportunity to. General partnerships come with a lot of great advantages. They're incredibly easy to start. Just like with a sole proprietorship, you simply start doing work and the RUPA is already in place to provide a framework to govern your business. The RUPA also provides the freedom to modify the terms to fit the needs of your specific business. Many people change the terms requiring each partner to receive an equal portion of the business profits to better reflect each partner's contribution. These modifications must be in writing. Taxes are also much easier to manage as each partner simply files their own personal income taxes and reports their profits as business income. However, general partnerships come with some drawbacks that make them unappealing to many. The first and most important of these is the fact that general partnerships have unlimited liability. This means that, like with a sole proprietorship, should the business fail, the individual partners have their own personal assets, their car, their house, their dog, all at risk. The partners all have joint and several liability. This means that while it is ideal that each partner should be equally liable for damages, it does not matter how the person who is owed something gets paid, only that they get paid. If you are in a general partnership with 6 people, and 5 of them have no assets, then it is possible that all that judgment ends up having to get paid by you. A person must be extremely cautious and only enter business with those they trust completely, especially if it is a general partnership. There is something called a joint venture, which can help protect people who do not intend to enter a long-term partnership. A joint venture is simply a partnership for a single event or activity. The definition of a partnership is quite broad, and you may not want to find yourself responsible for something unexpected or unrelated to what you're doing with this partner simply because you're co-owners of a business for profit. To enter into a joint venture, you must have an agreement specifically outlining the terms to include the sharing of profits and losses, the control of the business, and the duration and scope of the venture. A failure to do this clearly opens you up to the liability that comes from a partnership. Limited partnership. Limited partnerships do not fall under the RUPA completely, as they are a form of hybrid business organization. Limited partnerships provide the limited liability protection an investor wants, with the management and control of a general partnership. A limited partnership consists of at least one limited partner and at least one general partner, but it can have any combination of these. Limited partnerships are great for when you have someone who wishes to invest in a business but has no desire to manage it or to expose themselves to the risk of unlimited liability. In a limited partnership, the limited partner can only lose the assets that he has provided to or invested into the business. The downside is that the limited partner loses management and control of that business. All control rests with the general partners. They have the same unlimited liability, rules, and obligations of partners in a regular general partnership. To create a limited partnership, you will need an agreement explicitly laying out the roles of everyone. The absence of anything defining who the limited partner is simply makes them a co-owner of a business for profit. Seeing a pattern here? And places them at the same risk of a general partner. The great disadvantage of the limited partnership is that in most of these cases, the limited partner wants to have some voice in how the business is running, since they're the ones risking their money. They want a return on that investment. However, if a limited partner begins to attempt to manage the partnership or seek any real control, they may find themselves treated as a general partner subject to unlimited liability. If the partnership is sued, lawyers are going to be seeking out the person with the money. That'll almost always be the limited partner. If the lawyer can uncover sufficient evidence to show that that limited partner tried to manage the business in any meaningful way, then no written document defining him as the limited partner is going to save him from unlimited liability. When recovering damages against the limited partnership, the limited partners are the first to lose. Their investment in the business is liquidated to pay debts, court judgments, or other obligations. Following that, their limited liability protection kicks in and their personal assets are safe. The general partners are then liable for the remainder. Their liability, like with a normal general partnership, is joint and several. Limited liability companies. Limited liability companies have exploded in popularity since the 1990s. Limited liability companies, LLCs, are separate legal entities from their owners. LLCs are limited liability companies. They are not limited liability corporations. Corporations are a separate entity entirely. What makes LLCs unique is the simplicity of management and the limited liability protection. LLCs are owned by members. LLCs may be managed by the members themselves, member managers, or by separately hired managers. The limited liability protection of an LLC often makes it preferable to sole proprietorships or general partnerships, as your LLC can have as few as a single member. Like the previously mentioned business entities, LLCs also have flow-through taxation, requiring that the members report their business income on their personal tax forms. In some circumstances, an LLC may elect or be required to be taxed like a C corporation, but as we will see, that is rarely a good idea due to issues with double taxation. LLCs are simple to form. The members file a certificate of formation with your state Secretary of State, along with a filing fee. State laws vary, but your certificate of formation normally requires 1. The name of your LLC, 2. The name and address of your registered agent, 3. Your business's headquarters or principal office, and 4. How long the business should last. Your LLC's name needs something in it to make clear that it is an LLC. Since it is a separate legal entity from its owners, anyone you do business with needs to be on notice of the business's limited liability. Registered agents are those willing to accept service of process, the summons and complaint that we discussed in Chapter 2. An LLC may last forever, and many states consider this the default option if you decide not to fill this portion out, but you may set forth a time to dissolve the LLC if you wish. The major advantages that come with an LLC are the simplicity of formation, the flow-through tax advantages, and of course the limited liability for the members. The major disadvantages of this entity are the additional requirements placed upon it by the state. Often, this includes things like annual meetings of the members, renewal fees, or other obligations placed upon it by statute. Sometimes, as we will see shortly, an LLC provides a false sense of security, and if it is poorly managed, the other members will lose their limited liability protection when plaintiffs are able to pierce the veil and reach the members' personal assets. This is especially true in very small LLCs that are undercapitalized, intermingle funds, and serve as a simple alter ego for the members. Limited liability partnerships. Under your state's RUPA, there is also the option to form a limited liability partnership. Limited liability partnerships, or LLPs, are like a hybrid of a partnership and an LLC. LLPs are very popular amongst people in technical professions such as lawyers, accountants, architects, and doctors. A traditional partnership gives each partner unlimited liability. This can be especially frustrating if a partner does something wrong and you are held responsible for it despite having made no error yourself. And since liability is joint and several, a partner can do something that will get the partnership sued, and you can be the one responsible for the whole thing if no one else has any assets. With an LLP, partners gain limited liability protection from the mistakes of their fellow partners. To gain this protection, in addition to filing the necessary paperwork with the state, partners must have malpractice insurance covering their own actions. Corporations. Corporations are often misunderstood and maligned entities. We all know someone who, given any opening in a conversation, will rage about evil corporations and how they're destroying the planet, contributing to wealth inequality, poisoning our food supply, and probably breaking into elementary schools and stealing the kids' juice boxes. A corporation is really nothing more than a group of people coming together for a joint purpose and creating a separate legal entity under the protection and governance of state laws. Much like our country, a corporation is only as good or as evil as the people who control it. The historical record of corporations being either good or evil is very much mixed. There are several different types of corporations we will discuss briefly, but in this chapter we are primarily concerned with C corporations, the most common for-profit corporations. These corporations consist of 3 different elements: shareholders, a board of directors, and officers. The major advantages of a corporation are the limited liability protections offered to the shareholders/owners of the corporation, the ability to sell your shares and transfer ownership quickly and easily without disturbing the business operations, and its perpetual life. Corporations are also able to sell shares to raise capital if needed. Depending on your point of view, the fact that it is managed by professionals other than its owners may also be considered an advantage. A major disadvantage of a C corporation is the fact that its income is taxed twice. The corporation itself must pay taxes on its income first. Then, when profits flow through to the shareholders, the individuals must pay taxes on that income as well. Corporate tax is a complex area of law, particularly in the way it allows a business to claim losses against future earnings or other corporate deductions. But the common refrain that corporations don't pay tax is simply untrue. You and your friends start a small retail clothing shop as an LLC. You sell a coat to a customer. The profit of that sale is split amongst the LLC's members, and you each pay your income tax reflecting the money earned from your sales on your own personal tax form. Everyone is happy. You and your friends start a small retail clothing shop as a C corporation. You sell a coat to a customer. The corporation pays a tax on the profits from that sale. There's no point in a corporation earning money if the owners aren't making money. So after the corporation pays taxes on the sale of the coat, the remaining profit that is not used by the corporation to pay employees, purchase new supplies, or other internal needs flows to the owners/shareholders. The shareholders then pay taxes again on the profit from the sale of the coat. Parts to a corporation. Corporations consist of three different elements: the shareholders, the board of directors, and the officers. The shareholders of a corporation are the owners. The shareholders of the corporation all have limited liability. Consider how many people hold shares, stock, of a large corporation like Starbucks, Walmart, or Microsoft. Most of these shareholders have next to no control over the corporation and have no idea about what's going on with the business. In fact, most shareholders probably don't even know that they own shares, since their investment is part of an IRA, 401k, or some other retirement plan. In most cases, a shareholder is just someone investing in the business with zero interest in how it operates. The board of directors oversee the major business functions of the corporation. They make the larger decisions and steer the corporate mission. They also call together meetings of the shareholders to vote on various matters, such as dissolution. The members of the board will also determine whether dividends are going to be issued to the shareholders. The members of the board of directors are voted on by the shareholders. The board of directors also hire and fire the officers of the corporation. They also have whatever additional duties are assigned to them in the articles of incorporation and bylaws, which we will discuss shortly. Members of the board of directors can be considered inside or outside directors. Inside directors are shareholders in addition to their duties as members of the board. Outside directors do not have any ownership interest in the corporation. Regardless of whether members of the board are inside or outside directors, they still have a fiduciary duty to the shareholders, the same way partners in a partnership have a fiduciary duty to each other. This is the previously mentioned obligation to put the interest of the corporation above their own personal interest. Sometimes the shareholders are unhappy with the decisions made by the board of directors. Their primary recourse is to vote those members of the board out. Sometimes shareholders are sufficiently angry at the board that they will consider suing them. Unfortunately for shareholders, members of the board of directors are protected by the business judgment rule. Under the business judgment rule, so long as the members of the board are honoring their fiduciary duty and doing their honest, best work, they are immune from lawsuits from shareholders. Business decisions are risky. Sometimes they pay off and other times they don't. Without the business judgment rule, no member of the board would ever be safe from lawsuits. But their decisions must be researched, thought out, and be what the directors believe are in the best interest of the corporation for this protection to apply. Lastly, we have the officers of the corporation. The officers handle the daily management duties. They are hired by the board of directors. Common officers are your president, vice presidents, secretaries, chief executive officer, and chief financial officer, to name a few. How to make a corporation. To make a corporation, you must file articles of incorporation with the Secretary of State of the state you opt to incorporate into. Many corporations are domestic corporations. These are corporations that have decided to incorporate within the home state of their principal place of business. Many larger corporations opt to become foreign corporations. A foreign corporation is one that opts to incorporate in a different state. These corporations generally pick states that provide many business and tax advantages. Delaware is best known as a state many large corporations choose to incorporate into. Finally, we have alien corporations. Alien corporations are incorporated in other countries but do business in the U.S. When a business has chosen a state to incorporate into, they will file their articles of incorporation with the Secretary of State. State laws vary, but most articles of incorporation will require the following: the name of the corporation, the registered agent, the purpose of the corporation, the amount and type of stock, the par value of the stock, the duration of the corporation's existence, and the names of the incorporators. Like with the LLC, the articles of incorporation must have something in its name that lets people know that it's a corporation. This way, people that do business with it know that it is a limited liability entity. Most corporations will say whatever the business name is, a corporation, .corp, or incorporated, or Inc., or some other similar term. Corporations must also explain what their purpose is. Normally, corporations use very vague terms to explain their purpose. Instead of saying, we're a clothes shop, they might say something like, B-Law Inc. is designed for the purpose of conducting any lawful business purpose. This permits the business to branch out and provide more products and services than they started out with. Like an LLC, a corporation needs a registered agent willing to accept service in the event of a lawsuit. This is especially important if you have a foreign corporation, so there are no possible objections the business might have with the courts having personal jurisdiction over them in that state. Many corporations simply hire another company to serve as their registered agent and pay a small fee. Corporations, like LLCs, also may have a perpetual existence. Most of the time, a for-profit corporation will seek to have a perpetual existence. But sometimes, especially closely held corporations or nonprofit corporations may have a specific time frame they intend to operate for. The Articles of Incorporation must also address the different types of stock and how many shares of stock the corporation starts with. Corporations can always amend their Articles of Incorporation in the event they want to split their shares of stock. In addition to the total shares of stock, there must also be a par value established for the stock. This is the lowest possible price the stock may be sold for. Most corporations set this at or near 1 cent. When the Articles of Incorporation have been filed with the Secretary of State, the Secretary of State will return a certificate of incorporation. The initial shareholders will have their first meeting and elect the board of directors. The board of directors will then appoint the initial officers and approve the corporation's bylaws. The Articles of Incorporation are most comparable to the Constitution of the corporation. The bylaws of the corporation are more like the statutes or the internal governing rules of the corporation. The bylaws will outline which officers the corporation will have and what their duties are. They will outline how often the shareholder meetings will occur and what triggers the need for them. The bylaws of a corporation are often much longer and more expansive than the Articles of Incorporation. Stocks and shareholders. Corporations are owned by shareholders. Each share, sometimes called stock certificates, represents one divided interest in the corporation. If you own one share out of 10 billion, then you own 1/10,000,000th of that corporation. How many shares a corporation has, the different types of shares, and the rights and responsibilities of shareholders are spelled out in that corporation's Articles of Incorporation and bylaws. Shares of a corporation serve two major purposes: for the shareholders to exercise ownership over the corporation, and for the corporation to be able to sell shares of itself to raise capital for the corporation's needs. While there can be any number or types of stock outlined in the Articles of Incorporation and bylaws, the most common types are common stock and preferred stock. Common stock is, the most common type of stock. It is sometimes referred to as an equity security because you own equity in the corporation. Most large corporations consist overwhelmingly of common stock. Owners of common stock generally expect to make money by purchasing stock at a low price today with the hope of it increasing in value over time to be sold at a higher price. Common stock shareholders are also entitled to dividends. These are the profits the corporation has made that has been released to the owners instead of reinvested into the corporation. Corporations may also have preferred stock. Preferred stock is generally more difficult to purchase. Preferred stock has certain preferred values that make it more desirable than common stock. These values are listed in the Articles of Incorporation and bylaws, but in most cases, preferred shares are the first to receive dividends and may also get back dividends. This means that in previous quarters where no dividends were issued by the board of directors, preferred stock shareholders will be paid for those quarters before the common stock shareholders can receive dividends for present quarters. Any quarters where dividends were not issued to common stock shareholders are simply lost forever to them. Preferred stock shareholders also will be paid out for their ownership interest in the corporation prior to the common stock shareholders should the corporation be dissolved or purchased by another corporation. Each type of share, common, preferred, or other shares, will either be authorized, issued, or treasury shares. Authorized shares are the total number of shares that are set out in the Articles of Incorporation. Issued shares are those shares that are currently owned by shareholders. Treasury shares are those shares that are owned by the corporation. Corporations actually own part of themselves. Treasury shares are simply the authorized shares minus the issued shares. They're the shares that remain in possession of the corporation to be sold when it needs to raise capital. Rights and duties of shareholders. Shareholders do more than just purchase their shares and then hodl for dividend checks or to sell at a higher price. They certainly have the right to do that, but they can also vote on major resolutions set forth by the board of directors and can vote for members of the board of directors themselves. This is a sort of check and balances system within the corporation. The board of directors gets to determine whether dividends are issued each quarter. Shareholders invest in a corporation with the hope and expectation that a profit will be made and that they'll realize that profit. If the members of the board are constantly spending money internally on the corporation and not issuing dividends, then shareholders may become agitated. Equally so, if the board of directors is constantly issuing dividends instead of investing in the corporation, that may not be good for the long-term health of the corporation. The shareholders will vote to retain members of the board who are acting both in the best interest of the survival of the business as well as helping that shareholder realize the corporation's profits. How often and in what way shareholders get to vote is laid out in the Articles of Incorporation or bylaws. The most common ways shareholders vote is by either straight voting or cumulative voting. With straight voting, each share represents one vote. If a person owns 100 shares, they get 100 votes, and the person with 10,000 shares gets 10,000 votes. With cumulative voting, you take the number of shares and multiply it by the number of voting options. This allows minority shareholders the opportunity to mass their votes together to have a chance to defeat a majority shareholder in some instances. During an annual shareholder meeting for B-Law Corp., there are openings for 3 new members of the board of directors. There are 5 shareholders. Here's an example of how voting might look. Shareholder 1 has 5 shares of B-Law Corp. Shareholder 2 has 5 shares of B-Law Corp. Shareholder 3 has 5 shares of B-Law Corp. Shareholder 4 has 3 shares of B-Law Corp. And shareholder 5 has 50 shares of B-Law Corp. Other ways of raising capital. We've talked about equity securities, common stock, to raise capital for a corporation. Corporations also have the option to take on debt securities. A debt security is simply a loan. Debt securities do not confer any ownership right onto the owner the way an equity security does, unless there is some unique part of the agreement adding that. The main types of debt securities are bonds, debentures, and notes. The primary difference separating these are how secure the loan is and the interest amount. Bonds are generally longer term. They have some collateral behind them in the event the corporation cannot pay back the loan. That collateral could be stock options, property owned by the corporation such as vehicles or real property, or something along those lines. Because there is collateral, the interest rate is kept lower. The more secure the loan, the lower the interest rate. If there's a default, the person who is owed can mitigate their losses with the collateral attached to the loan. They're at least getting something instead of simply losing everything they loaned out. Debentures are medium to longer term loans. They have no collateral behind them. In the event the corporation defaults, there's no real recourse for the person owed. Because of the higher risk, there is a higher interest rate. Notes are shorter term and can either be secured or unsecured. Secured loans are those with collateral attached. The interest rate will be determined based around these factors. Mergers, acquisitions, and dissolution of corporations. Corporations may merge with other corporations or dissolve themselves. In these situations, the board of directors will make a recommendation for such action after doing their research, but it will be the shareholders during shareholder meetings voting on whether they follow through with the dissolution. If a merger or acquisition happens, what remains will be the merged corporation and the surviving corporation. The merged corporation will be the one that is purchased, and the surviving corporation will be the one left behind. When a corporation is purchased, it is not just purchasing the other corporation's assets, but also its liabilities. The surviving corporation cannot simply tell those owed by the corporation that they're out of luck. The surviving corporation must make good on those debts. When the shareholders elect to dissolve a corporation, the matter can become quite complex. The corporation will file articles of dissolution with the Secretary of State. The board of directors will be tasked to carry out the dissolution unless the dissolution is made by court order. If the court is ordering the dissolution, they will order an order, decree, or judgment of dissolution, and the court will likely appoint someone to wind up the corporation as part of that order. Sometimes the dissolution is ordered by the Secretary of State. Dissolutions may also happen with any other business entity that has been formed through the state. The Secretary of State will issue a certificate of dissolution. In most of the cases where the Secretary of State dissolves the business entity, he's simply cleaning up after a business has already dissolved but didn't necessarily do it properly. When a small business fails, they often just quit instead of wasting time, energy, and resources to dissolve properly. Dissolutions can be an especially contentious time. Most of the time, if a corporation is dissolving, it is going out of business. If a business is making great profits, no one's going to want to dissolve it. If a business is dissolving, you have a lot of people fighting over the few remaining assets. That business has employees, the board of directors, people owed debts, other contractual obligations, and let us not forget the actual shareholders of the corporation. Everyone is going to want to get paid, but some people are going to be left out. This often leads to lawsuits to determine who is getting paid and in what order. Alternate corporate types. So far, we've talked about the most common types of corporations, C corporations. However, not all corporations follow the same rules. What follows are some different types of corporations. Sub-S corporation, or S-corps. One of the most common corporate types is the sub-S corporation. The sub-S is unique in that it has flow-through taxation, much like a partnership or an LLC. This means that it is not double taxed the way a standard C corporation is. To gain this benefit, there are special rules by the IRS that must be followed. One of the primary rules is that there is a cap on the number of shareholders the corporation can have. The number has changed over time, but currently stands at 100. A sub-S corporation is a good middle ground between having an LLC and a C corporation. In most circumstances where a person might opt to choose an S corporation, an LLC is the better choice. The largest major benefit an S corporation provides over an LLC is the ability to sell stock to raise capital, though the 100 shareholder limit can affect this benefit. Some states provide various benefits and obligations to different entities that might impact whether a business chooses an S corporation or an LLC. B corporations. There's been a growing interest over the last several decades for corporations to demonstrate more ethical behavior, requiring them to consider more than simply the profits of their shareholders. This call for corporate social responsibility has resulted in the creation of the B corporation, sometimes called a benefit or a public benefit corporation. States have enacted statutes permitting the formation of these B corporations since the mid-2010s. Because of this, there are still a lot of questions surrounding the requirements of a B corporation and an absolute dearth of case law. B corporations must still file with the IRS as either a C or S corporation, so there is no major tax advantage to this corporation. What makes the B corporation unique is that the business must have some public benefit as part of their mission statement. This is likely to be stated as part of the purpose portion of their articles of incorporation. Additionally, the board of directors of a B corporation must consider not only the profits of the shareholders, but also the stated public benefit as one of their fiduciary duties. A B corporation is not a nonprofit, so this conflicting need to maximize profits and the public benefit is surely to create issues that will be addressed in statutory and case law in the coming years. This is a growing area of law, so the rules are still settling. State laws vary, but there is no specific governing body dictating whether a corporation is adhering sufficiently well to their public benefit mission. A corporation could present themselves as a B corporation as a simple veneer of corporate social responsibility, sometimes referred to as greenwashing, to maximize this attraction to potential customers. Privately held corporations. When we think of corporations, we often think of very large corporations like Apple, Walmart, Starbucks, or Amazon. We think of corporations that we can purchase shares of on the stock exchange. Not all corporations are publicly traded, though. Some corporations are privately or closely held corporations. Privately held corporations are not publicly traded and have strict limits upon the sale and purchase of shares. There is no size requirement for privately held corporations. Although in most cases these are smaller in size, this is not always the case. SpaceX, for example, is a privately held corporation. There are many reasons why someone would choose to create a privately held corporation, but the main reasons are a desire to keep control of the corporation within the hands of specific people, such as family or friends, or a desire to keep the business's mission a priority without the pressure public shareholders would place upon it to make a profit first. There are several ways a privately held corporation may attempt to keep control in the hands of a select group of people. In the Articles of Incorporation or bylaws, there might be a clause granting the right of first refusal to purchase the stock or some other form of consent restraint prior to shareholders selling their shares. The right of first refusal means that prior to selling their shares, a shareholder must first offer to sell their shares back to the corporation itself. If the corporation refuses to purchase those shares, then the shareholder may sell their shares to someone else. Consent restraint means that the other shareholders have veto power over your sale. The shareholder would propose to sell their shares, but could only do so with the consent of their fellow shareholders. This is especially helpful to ensure that the new shareholder is not someone who would derail the corporate mission, such as a fossil fuel advocate purchasing shares of an electric motorcycle company. Nonprofit corporations. Nonprofit corporations serve some public benefit. However, they are not required to be B corporations. A B corporation can still be for profit. Nonprofit corporations generally have special tax advantages other corporations do not share. Besides the tax advantages, one of the major differences of a nonprofit corporation is the lack of shareholders. No one owns the corporation. The purpose of most corporations is to make a profit for the shareholders. Without a profit for the corporation, there is no purpose for the shareholders. No one owns the corporation, not even the founder. That is not to say that nonprofit corporations cannot charge money for things. They still have a board of directors and officers. In nonprofit corporations, the officers and members of the board may be handsomely compensated. It's a good practice to consider how much of the donated money truly goes toward a nonprofit's mission, as to how much goes toward internal spending on parties, elaborate fundraiser events, or officer compensation packages. Municipal corporation. Municipal corporations may not seem like actual corporations, but they are. All a corporation is a group of people coming together for a single purpose who organize an entity under the state's corporate codes. Most cities are nothing more than municipal corporations. These corporations have the powers granted to them by the state under state statutes. This includes the power to create law and sometimes the power to tax. The requirements to create a municipal corporation, the powers they have, and the limits to their authority are all dependent upon state statutes. Consider when you drive through very small, unincorporated towns in your state. These are all gatherings of people into a community, but they lack the powers of a traditional city because they have not incorporated themselves the way required by state statute. Franchises. A franchise is not a business entity itself, but rather a business model. One of the previously mentioned business entities, like an LLC, partnership, or corporation, will enter into a contractual relationship with another business. What they gain from this relationship is a right to that company's image, their intellectual property, business model, and unique practices. When you go to a McDonald's, even though it does not feel like it, you're often purchasing from a small business owner. There are many advantages in entering into a franchise agreement. Most franchises are well-established brands. There's no question that people go to eat at McDonald's. We know that their food is popular. Some franchisors, the owners of the franchise chain, will aid their franchisees, the individual store owners, by sending experts to teach them the ropes and to ensure that businesses know how to create a product that meets the franchisor's standards. Further, a franchisee knows that they have a larger business entity there to advocate for them on legal and political matters. One should not become overconfident about entering into a franchise agreement, as there are many drawbacks. You're going to be entering into an agreement that gives large portions of your income over to the franchisor. Some franchisors require to be paid fees, while others demand a portion of your income. Most do a combination of these. While the franchisor wants you to be successful, they aren't in business for some altruistic desire to see you make money. They're in business to make money from you, so the agreements you enter will often be adhesive contracts that don't allow you a lot of room to negotiate. You need them much more than they need you. and they know it. Another drawback of operating a franchise is that you lose a lot of the freedom that comes with running your own business. If you're operating a burger franchise deep in red state cattle country and the franchisor has a vegan burger option, if they tell you to, you're going to be offering that vegan burger even if you're losing money on it. People also frequently find themselves overconfident when they enter a franchise. Just because McDonald's is popular doesn't mean that your McDonald's is going to be popular. Franchises fail at comparable rates to other businesses, so you still need to have good business sense to succeed. Agency and authority. Many of these business entities exist as something separate from its owners. An LLC, corporation, or partnership can enter into contracts or otherwise conduct businesses in its own name. But a business isn't an actual person. It needs a person to conduct business for it. Someone with the authority to speak for the business on legal matters has agency. Recall that a person who is willing to accept service, providing personal jurisdiction for that state's courts, is their registered agent. The three types of authority we're going to talk about are express, implied, and apparent authority. Express authority is simple. In a business's operating agreement, be it an LLC's certificate of formation, a corporation's bylaws and article of incorporation, or a partnership's operating agreement, it will be written exactly who has the authority to do what actions. Authority is expressly given to individuals. This ensures not only that the person can serve as an agent to do what is needed for the business, but also that individuals know the limits to their authority. You may want to make sure people only do specific tasks, especially in larger businesses. Many officers and corporations are given express authority to conduct their business only in their unique areas. Authority is not limited to this type, though. Implied authority is a little more nuanced. With implied authority, there's nothing in writing expressly outlining the authority an owner or an employee has. Partners in a partnership, members in a member-managed LLC, or corporate officers have implied authority to do tasks related to their business. For example, if you were a partner or employee of an auto parts shop, you'd have the implied authority to purchase parts from manufacturers. You would not have the implied authority to purchase ice cream, even to sell for the business, since there's no connection between ice cream and auto parts. Apparent authority is like implied authority, but is much more in relation to the third party who contracts with the business. Apparent authority exists when it is reasonable for the third party to believe that the individual had either express or implied authority. Let us say that an employee or a partner in a partnership for our auto parts store has been expressly told that they do not have the authority to purchase parts from a manufacturer. But they, thinking they know better than everyone else, do so anyway. The manufacturer then goes to the business and demands payment. The business refuses, saying that the employee lacked authority to make the purchase. If the manufacturer sues, he will win because although the employee was denied express authority to purchase the parts, it's reasonable that the manufacturer believed the employee had implied authority since he works at a parts store. He therefore has apparent authority and the business must pay. Take this same scenario, except this time the employee purchases ice cream to sell at the store. The ice cream shop owner demands payment and the business refuses. If the ice cream shop owner sues, he will lose in court because it is not reasonable for him to assume that an auto parts employee would have the authority to purchase ice cream in the name of the business. The employee lacks express, implied, and apparent authority. Lawsuits against businesses. Suing businesses can present some additional difficulties beyond that of suing another individual. We've already discussed in Chapter 2 how businesses may present issues of personal jurisdiction. An additional issue a plaintiff may face when suing businesses is recovering assets when that business entity provides limited liability protections to its owners. There is also the matter of when an employee's actions are sufficient to sue the business itself instead of the individual employee. When an employee makes a mistake causing injury to another, the plaintiff often has the option of suing the employee personally or the business itself. The plaintiff's attorney will almost always recommend suing the business over the employee, although sometimes you will sue both. The plaintiff will follow the money, and the business is almost certain to have more money than its employees. Under the doctrine of respondeat superior, the business can be held responsible for the acts of its agents such as the employees or owners. Respondent superior is Latin for let the master answer. Look at you, now you've got a Latin term. You've got some party tricks now to whip out and impress people around the dinner table at Thanksgiving. To apply this doctrine and hold a business accountable for its employees' actions, you must prove that the agent acted within the scope of their employment. If they were operating within working hours, using their work vehicle or tools, wearing their work uniform, or otherwise doing their job when they caused this injury, respondeat superior applies. If the employee was out in town after work hours, on their own time doing something not related to their job, then respondeat superior does not apply, since the business had no actual control or responsibility over the employee at that time. There is also the matter of the limited liability protections certain business organizations offer to their owners. As we've discussed, LLCs protect the personal assets of their members/owners, and corporations protect their shareholders/owners. In most circumstances, this isn't a real problem because if you have a debt to recover or a court judgment against a business, the business will be held responsible and you will receive payment out of that business's assets. But if that business doesn't have sufficient assets to cover the judgment, then you'll want to try to recover from the owners. This isn't easy because they have limited liability protection. This is why you get limited liability protection in the first place, to protect your assets. To get to the personal assets of the owners, you need to pierce the veil. Piercing the veil means to pierce through that protective bubble provided by the business organization's limited liability protection. This isn't easy, but it is possible. There are a few things you can do to pierce the veil. On the flip side, if you're the one with the business, these are practices you want to avoid. The first way to pierce the veil is to show that the business has undercapitalized itself. There is an expectation that if you have a business, that the business will own property. It will have its own banking accounts with enough money in the accounts to cover any problems that arise. Perhaps it owns its own inventory of property that it sells. It should own its own vehicles and tools and perhaps even real property. But if all the property the business uses belongs to the owners instead of the business, you may be able to pierce the veil. The second way to pierce the veil is to show that the owners are intermingling their personal funds with that of the business. If the business makes a sale, and instead of going to the business's accounts, the money goes directly into the owner's personal banking account, then they have intermingled their personal selves with the business. This often will align with an undercapitalized business, but it doesn't always overlap. A third way to pierce the veil is to show that the business is not following the requirements placed on it by either the state statutes relating to the business or that they're not following the rules of their operating agreements, such as the LLC's certificate of formation or corporation's articles of incorporation and bylaws. This can include things like not having annual meetings of the shareholders or LLC members. What this all really comes down to is that no limited liability protection is absolute. If the business is operating as a fake alter ego that only really exists on paper, while the real business is being done behind the scenes by the owners, then those owners might be held liable regardless of how they've organized themselves. A business is supposed to be its own unique entity, not a false front that exists only to protect its owners.